Hi students, Nyandu here. Today I am looking at your first assessment and I'm looking at question 1.3. So again, I'm here just to give you some pointers and some feedback based on the answers that you guys submitted. This is not going to be a comprehensive video. So let's begin. So 1.3 deals with, this is the question. If the charge of murder cannot be sustained, do you believe that they would be convicted of a lesser offense of culpable homicide, the negligent killing of another human being? Discuss what will be required to prove negligence. Okay, so here we're dealing with negligence. Remember, students, whenever you answer a question that asks you to prove an element, you need to first discuss the element. You need to tell the judge what the element is about. For example, you need to tell the judge or tell your examiner or tell the person that you are advising that negligence is something that falls under faults, right? You need to tell that it is objectively determined. However, there are some subjective consideration because the person on the other side needs to know that it's an objective test and that there are some subjective considerations that also fall under negligence. Okay, you need to tell the person that in terms of negligence, we say a person's negligent because their conduct fell short of what society expected of them in the circumstances. Okay, so that's another thing. Another thing that is quite important insofar as explaining negligence is the fact that we use the hypothetical reasonable person's test. Okay, so these things are very elementary. These are the things that you need to state before you go and discuss or you prove negligence. Okay, so once you've discussed these three things, objective standard with some subjective consideration, a reasonable person's test, or a reasonable person, and the fact that when we say a person is negligent, we're saying that their standard of care fell short of what society expected of them in the circumstances. So those are the three things, right? So then the next thing you need to do is obviously give me the test for negligence, right? I would advise you guys to memorize this test of negligence because often when you paraphrase the test of negligence, then you miss some information and then it doesn't become what it should be, and therefore you lose marks. So some of you straight off the bat just stated that negligence is divided into two categories: preventability and foreseeability. No, that's not your starting point. Your starting point is to write down the test that was given in Rath or in Kruger versus Coetzee. Just write it down, okay? So some of you went ahead and wrote down the test. You spoke about that culpa arises if a reasonable person in a position of the defendant would have foreseen the possibility of harm. A reasonable person would have taken steps to prevent the harm. And then that's where you stopped. You didn't write the last step and the defendant failed to take those steps. This is not the complete test for negligence, right? You have to write down all three steps. Okay, so some of you lost marks for that. Okay, once you've written down the test for negligence and you said A, culpa arises if a reasonable person in the position of the defendant would have foreseen the possibility of harm. B, a reasonable person in the position of the defendant would have taken reasonable steps to prevent the harm. And C, the defendant failed to take these steps. Okay, you've done that. So now you're going to break it down and answer the question based on the three stages. The first one is, would a reasonable person have taken steps to prevent the harm? Now, some of you were guessing or were using general knowledge to say that in such a case, a reasonable person would know that if you drink and drive, that harm would be foreseeable. No, there's a formula to this. There's a formula to how we determine whether a reasonable person would have foreseen the possibility of harm. And this formula was discussed in the case of Sea Harvest. This formula was discussed in the case of Sea Harvest. Let me just check. Okay, beg your pardon, in the case of Lumanguti, sheet metals and engineering. So this is where the test or the formula to try and determine whether a reasonable person would have foreseen the possibility of harm. So you can't just thumb suck this and say a reasonable person, right? Even though you might know the answer and the answer might be right, but if you don't use the correct formula, then you're not going to get any marks for it. Okay, so this is how you determine whether a reasonable person would have foreseen the possibility of harm. You look at the three factors that were mentioned in the case of Lumanguti versus and sheet metal. Those three factors are the following. How real is the risk of harm eventuating? What is the likelihood of harm actually occurring from the conduct in question? Secondly, if the harm does occur, what is the extent of the damage likely to be? Thirdly, what are the costs or difficulties involved in guarding against the possibility or the occurrence of harm? So these are the three things that you're going to tell the judge or the examiner that they need to consider using the facts in trying to determine a reasonable person or to foresee the possibility of harm. So once you've written that, so you can write down all your law, or after writing down this law that I've just explained, you can explain. So let's just do that. So you've told me the three factors. Now let's look at the scenario. What is the likelihood or the likelihood of harm eventuating? The likelihood of harm eventuating is quite great. Why? Because they are drag racing, okay? There are kids on the road, okay? They are also under the influence of alcohol. The likelihood of harm occurring in such instances is high. But that on its own is not enough for us to say that um, um, a reasonable person will foresee the possibility of harm. You need to also consider the second point and the third point. And the second point in this regard is the following. If the harm does eventuate, what is the extent of the damage likely to be? So if the harm does eventuate, what's the extent of the damage likely to be? In this case, it's likely to be great because lives could be lost. If you're drag racing on a road where kids are and you're under influence, if harm does actually occur, then there's a potentially that life would be lost. That's quite great. And then the last thing is, what are the costs or difficulties involved in guarding against the harm? What are the costs or difficulties involved in guarding against the harm? Here, there aren't that much cost or difficulties that are involved in guarding against the harm, because what is simply required is the following: just not drink and drive, right? They could have done that reasonably easy. So I just want to refer you to something quickly, because before you even apply these three factors to the scenario, you need to tell the court how these three factors are weighed. So you need to tell the court how it's going to weigh these three factors. And I just want to look at this for a little bit. So we're dealing with negligence. Okay, let me just pause the video.